What which has wrongly come for motion, it ought to have come for my lord bail hearing, and I am under interim protection. If it pleases my lordship, the matter may be listed after vacation and the interim may be continued, subject to what my learned friend PP has to say.
Matter has already been fixed. Whether you have received any case diary. Case diary already received. So you want any adjournment here?
Adjournment, yes, my lord. If after immediately after the vacation, my lord, that would be convenient for the learned senior counsel.
Mr. B. H. Chaudhary, the learned counsel for the petitioner. The request made by him. Let the matter be listed immediately after vacation hearing for 20.
My lord, interim may be continued.
Yes. Interim be continued till next date of listing. CDB return, calling for an update.
I stand most deeply obliged, my lord.
May I please, Your Lordship? Your Lordship, I beg to mention on BA for listing for withdrawal tomorrow, Your Lordship. And another BA, Your Lordship, filed yesterday, Your Lordship, for listing day after tomorrow. BA, Your Lordship.
What to do? Any matter. Okay. Thursday.
I know.
May I please, Your Lordship? My lord, I beg to mention for listing a AV, my lord, on tomorrow, my lord.
AB, you can approach registry.
Obliged.
A, we are considering AB, you can approach it.
My lord, I am praying for regular bail application, Lordship. May I pray, Lordship, on the Friday, Lordship?
To last working day, I don't know.
Friday or Thursday, Lordship?
Thursday.
Well, another,
Thursday.
my lord, another criminal petition, Lordship.
Make a mention before Justice Monitor.
Bless.
May I please, Lord? I beg to mention item number 27, Lord.
20.
27. Conducting counsel, Mr. N. Annual. I have taken consent from the other sector. Nothing may kindly.
Is unwell.
Yes, Lord.
Mr. N. Hassan.
Yes.
Unwell. With the consent.
May kindly be listed after vacation.
You want to hear fixed date or after vacation will be?
After vacation.
After vacation. After vacation. As in date.
May it please, Your Lordship. I beg for listing of a bail application for tomorrow, Your Lordship. The urgency is that it is under section 108 and the police have arrested the petitioner only on mere suspicion.
No, these are the matters.
Then on Thursday, Your Lordship.
Thursday already many matters have been fixed. Okay, sir.
Deeply obliged.
Please, Your Lordship. Lordship, I am praying for listing of a bail petition
Huh?
for withdrawal.
Okay, tomorrow.
Good, tomorrow.
Lordship, one regular bail application I have filed on 12/12/2024. Then on Thursday, Lordship.
Thursday lot many matters.
Regular bail, Lordship, it will
Maybe
jail.
Friday.
All their motion, this.
Okay, Thursday.
May please, Your Lordship, with the consent of the other side, I will what flags from item number 38 also. Also, the matter may be adjourned for the day and the date may be fixed.
You are for the petitioner?
Respondent, Lordship. Respondent
Have
number
you
2.
taken consent of the other side?
Yes, sir.
With the consent of the other side, consent for the respondent. 8.9 prayer allowed. This matter of after the petition.
Lordship, the date may be fixed.
After vacation, no date.
Obliged.
May I please, Your Lordship? Lordship, I am praying for listing of a regular bail application, Lordship. Already I have filed yesterday, Lordship. Let it be on
Now,
Thursday.
we are not in a position to for listing the matters because 60, 70 matters have been already fixed.
Already, any day, Lordship, Thursday or Friday. Lordship.
Any days is up your
Because there
case.
will be many
We are
benches, Lordship.
accommodated.
Because all are motion days.
No,
Lordship.
no. We can realistic approach for better to approach registry. If it can be accommodated in any other court, it's okay. Approach registry.
Lordship, I have one more prayer, Lordship. I am praying for a listing of an appeal, Lordship, criminal appeal.
Make
Where
a
the-
mention before Justice Manish Chaudhary. Justice Manish Chaudhary, senior batch.
Meet with your lordships. I took consent from the other side, my lord. Item 42 can be possible for the day after vacation. Madam. 42.
It's a bail application.
No, criminal
40?
petition.
Oh, sorry.
42 supplementary list
Okay.
after vacation, my lord.
You are for the petitioner.
Petition.
with the consent of the others, the learned counsel MSKJB, Bitcoin and fair draft is the matter. Yeah. It will be listed after vacation.
Hello.
Wait, please, sir, lordship, my lord. Sorry to mention, my lord, yesterday I came before your lordship for mention to list the motion matter, my lord. Accordingly, your lordship asked to approach the registry, my lord. Accordingly, we approached the registry, my lord, but registry refused and
What
told
kind of
to
AB?
AB, my lord.
AB we are not. AB we do not find any urgency because 2-3 days left. So
Because, my
that's
lord,
why I asked you to approach registry because of the intention behind it. If you can approach the registry may accommodate your matter in any court. That is the reason why I'm asking you to approach the registry. We are not in a
because,
position
my
to
lord,
say, then
registry
it will
refused
be
to,
listed after vacation.
my lord.
AB we are not listing.
Since the matter filed on 12/12.
So
my lord.
whatever we are listing, if you insist on, then it can be listed or after vacation, immediately after vacation. Or better to approach registry. Why I'm saying because registry may accommodate your case in any court. That's
Right.
why. Because all mention we are not allowing, especially AB we are not allowing because 2-3 days only left. It will not be possible on our part. That's why. Approach registry. Okay.
May I please, Your Lordship? I beg to mention listing for withdrawal, Lordship.
Withdraw tomorrow.
May I prefer listing for regular bail application any date, my lord, for vacation?
Registry.
Any date, my
Date we don't have. Any date after vacation.
before vacation.
Before vacation, we don't have any date. What a kind of just submission. Today नहीं आता है तो जो mention allow को provide Thursday तो already बहुत किया बहुत हुई Thursday तो declared Friday.
Public.
May I please, Your Lordship? I beg to mention item number 28 and item number 29. Kindly adjourn this matter today and fix it on 7 January, Lordship.
28 and 29.
Yes, ma'am.
But I don't think 28 and 29 are not connected. 29 is connected with 30.
Yes.
You are appearing in 30 also?
Alright.
Oh, sorry, it's not connected. So you are mentioning for both 28 and 29.
Lordship.
You are for the petitioner. The state is the other side or any other respondents are there? Only state, ne? Yeah. Adjourn for it.
Wait, please, your lordship.
After vacation. Date now.
Wait, please, your lordship. Therefore, a listing of a bail application for withdrawal tomorrow. Deep cases.
May please, your lordship. My lord, I like to mention item number 19 and 20. It may come after vacation, my lord. Admission
19 and 20.
19 and 20. After vacation.
In both the matters, you are for the petition.
Same matter.
But in the others, on the item number 19,
They have filed the
one Mr.
affidavit.
Enkarita and A. Chaudhary's name is.
Yes,
Yes, lordship.
You are there.
I'm informed.
and he's also appearing in the 20 also.
20
20 also you
lordship,
are
he has not received any notice from the court, your honor, lordship. But I have informed him that one case is pending. In the trial court, lordship, I am for the respondent number 2 in 20, lordship.
So you can appear in
Yes,
that
Yes, but copy is
I'll give you a copy today. So
basically for the item number 20.
20.
You have not received the copy.
Yes.
Where the copy?
I'll give the copy
So you want it fix it after vacation?
after vacation.
Want any fixed date here or?
Fixed date means, because I need to file also, they have filed the affidavit. I need to file a reply also.
Then
So let
immediately
me
after
file the
vacation,
reply, then we can fix
then,
the date.
no. Immediately after.
Date
In
may-
both the matters, you are going to file a written.
In one matter, 19, he has filed the affidavit in opposition. So I may give some reply to that. In 20, I don't know whether he will file the affidavit or not.
And I've been
Matter is same, out of the same issue, matter.
File their affidavit. Okay, so this time we are not fixing any date. and
No,
we'll
but
provide
after
you a
affidavit,
copy.
we can put.
copy during the course of.
Because I need to obtain certain certified copy from the lower court also. What time it will avail there? Okay. Any,
Vacation.
It is a lordship. I'm taking for listing of a bail matter for motion, my lord. On Thursday, my lord, if possible. Bail matter.
Thursday
Be
will be possible, I think. Okay, then.
I'm taking.
Well, item number 5, which was already mentioned, my lord. Matter may come up for bail hearing on the next date. my lord.
Yes, I have already.
Come up. May I please, your lordship. Lordship, item number 22, it's a bail hearing matter. LCR is received. Lordship, may kindly allow me to go through the LCR, lordship. I want to check the last order.
22.
Yes, the 20.
Okay, in the office hours, you can.
High level.
may it please your lordship. Lordship, I want to withdraw this case.
As per instructions of your client. Your good name?
R Islam.
R.
R Islam.
You are appearing on behalf of whom? Your name is not reflected. You are appearing on behalf of whom?
A Hawari.
A Hawari, na?
Yes.
Appearing on behalf of A. But not. Okay, we had passed the order. It will be disposed of on withdrawal.
Deeply obliged.
May I please, lordship, regular bail application, my lord. It's a POXO matter, and it has been charge sheeted, my. My lord, at this stage, my lord, scan copy of TCR may be called for.
What a case charge sheeted, whether who is necessary in that case also it is necessary.
Yes, ma'am.
Heard you are Mr. M. Ali.
Lordship.
Heard Mr. M. Ali, the learned counsel for the petition. Also heard Mr. P. Bot, the learned petitioner. I like to notice to the respond number 2 through jurisdiction police station routed to the office of the registry in the public sector. Steps will be taken within 2 or 3 days. Further, call for the scan copy of the TCR. Scan copy of the TCR, the registry will look in it. To take steps for the respond number 2. In the meantime, we are calling for the scan copy of
Lordship, immediately after vacation, it will. I'll take a step today.
21 will do.
Can it be earlier, my lord? 131 days already.
8 of January.
Highly optimistic.
May I please, your lordship. The intermediate quantity NDPS Act, my lord. So case diary may be called.
Since when he is in custody?
21/11, my lord. So will be for
Immediately
27 after vacation, my lord, 7th or 8th, my lord.
7.
7th.
It will be called 7.
Deeply
We will
obliged.
listing on 7.
May it please your lordship. Your lordship, NDP is small quantity. However, section 27A was attracted. Already 86 days behind the bars, your lordship. And
But
furthermore,
27 till A is there.
for that matter,
27
the same FIR, the case is fixed tomorrow in court number 22, your lord. It may be fixed tomorrow along with the same FIR.
Okay, what is the other number?
Serial number 21, court number 22, your lord.
No, what is the number? Number of case? Yes, number.
Just
City we call for estimator according to
your lordship, bail application 3730.
3730.
Your lord. Public 2025. Court number 22, I don't know.
We will listing it tomorrow along with bail application number 3730.
Deeply obliged.
Put
May I please, your lordship, call for the city lordship, actually lordship, the small quantity lordship. 27/11 arrested lordship. The with shop box lordship 12 grams lordship. With shop box lordship. The page 19 lordship, last
6-1. How many days till now?
Uh,
What is your
28
period of custody?
from
18 days.
27/11.
7/11, that means
Yes.
it's 1890 days.
On
18 days.
fifth lordship, reopen the court lordship. Fifth lord,
Fifth may not reach
sixth lord.
6th of typical.
Six.
Made please, your lordship. As a pre-arrest bail, my lord, your lordship will find the FIR, my lord, at page 11. My lord. May I read, my lord?
Yes.
I have the honor to report that on so and so, I, along with my friend Shahan Ahmed, had traveled to Silchar for our personal work. While returning towards Baga Bazar, we stopped at so and so point to have tea. At that time, two unknown persons approached me, inquired my name, and informed me that one Shah Alam Majumdar wanted to speak with me. They instructed me to wait in so and so point, stating that Shah Alam would arrive with a few minutes. Well, I am Shah Alam before your lordship. After a short while, Shah Alam Madhur Bhuiya arrived in a Maruti Suzuki bearing register number so and so and directed me to sit inside his vehicle, in which four other persons were already present. Thereafter, they forcefully took me towards the nearby bridge on Aizol Road, where 4 or 5 additional persons were present and compelled me to call my close friend so and so, instructing him to come to Sonarighar. Shah Alam informed me that he had some money-related dispute with him. Subsequently, Shah Alam Badar Bhuiya and his associate took me to various locations in the Silchar area in the said vehicle and eventually transported me to so-and-so road. During this period, they used criminal forces, intimidation, and threat against me and forced me to demand 7 lakhs from my friend and family members in exchange of my release, my lord. Now I am skipping, my lord. The lordship will see from below third paragraph, my lord. At about 12 a.m., the police traced my location and rescued me safely from the clutches of the miscreant group who had compelled me to remain on the railway bridge and thereafter fled through the railway bridge passage over the Borak River. The police also recovered one of the vehicles used by the miscreant during my kidnapping, which I identified the spot, my lord. My lord, the police rescued from the clutches of those persons, my lord. I was there, my lord. If he has been kidnapped, my lord, the police would have apprehended us on that point itself, my lord. My case, my lord, I have narrated, my lord, page 3, paragraph 5, my lord. That the petitioner begs to state that the fact is that the informant and his close friend Shahan Ahmed had borrowed money of rupees 7 lakhs from the accused Shah Alam Madhur Bhuiya for business purpose, but they could not return the money timely. So the accused requested the informant and his close friend again and again to return the money, but they did not agree to return the same. Consequently, on the incident day, an altercation took place amongst them and regarding money at Mojumdar Bazar, where the other accused persons were also present. Then the informant called his friend Suhel and his uncle over phone to settle the matter. But his friend and uncle informed the police. Thereafter, the informant made this allegation. Well, it's true, my lord. There is a altercation, my lord. Something happened, my lord. But kidnapping and that part is not there, my lord. Because police, he says in the FIR, the police has recovered from the clutches of those, my lord, those persons, my lord. I was there, my lord. The police could have arrested me, my lord. It is a fact, my lord, that he borrowed money, my lord, and that he could not return it, my lord. So that's why this FIR, my lord.
Although, my lord, at that point of time, my lord, accused persons were there at that
yes,
in the place of the occurrence, but it is also specifically mentioned that thereafter they fled away from the place of occurrence.
Thereafter.
And their vehicle.
Is there anything in regards to the transaction of 7 lakhs, or was there the informant in any manner deposited the amount?
Yes, that regarding only it is my lord, there in the FIR that my lord transferred rupees 11,000 from my bank account, but to whom, by name of the person, that amount to whom, my lord, that amount transferred, my lord, his name is not there in the.
Only 11,000, my lord.
Possibly, my lord, 1, 2, 3, 4th paragraph, my lord. And further forcibly transferred 11,000 from my bank account to another account. But in whose bank account, my lord, that amount has been transferred, his name is not there in the FIR.
Apart from that, suppose if demand was suppose of 11 lakhs,
Yes.
then with the only transfer of 11,000, then
Yes.
seems a bit.
Because it seems that dispute is between someone, between the accused and with someone other.
Had Mr. N.J. Datta, the learned counsel, had and it said it's an application, section 20, next. Next paragraph submitted by Mr. Datta, the representative. Is not committed any such said that I will be. However, it is the fact that there was a 7 lakhs is as the informant borrowed received some, and in spite of several requests made by the he did not return the money. And on that context, between therefore there is no any incident of kidnapping that occurred. More so from the FI itself, it is seen that he was rescued safely from the classes of the miscreant groups without any harm to this person, and no accused person be apprehended by police at the time of his trial. However, the petitioner is very willing to extend his cooperation. Next, about the learned edition submitted in this trial that city may be called for to know the actual fact of the case. However, from the FI itself, it is seen that rupees 11,000 was possibly transferred from the bank account of the present petitioner to any other account, to another account by considering the submission and the submission made by the fiscal extend the privilege of interim to till principal. Okay, you'll be under interim protection.
Madam.
CTP code
21?
21-1
Yes, 20.
I have to appear within my lord.
within 7.
I'm obliged, my lord, deeply obliged.
May I plead your lordship?
Your lordship, and the interim bail, an anticipated bail application has been filed by us within the section 42 against the against the section 118 and 103 of BNS.
See, there is 103, nee?
Yes.
That means case of murder.
Yes,
Yes, Lord.
actually victim expired money.
Your lordship, along with the FIR, we had also along the FIR that is filed by the informant, being the petitioner, we had also filed a cross FIR on the same day.
Your cross FIR has already been registered?
Yes, your lord. Your lordship, if your lordship may allow, may I read the FIR, your lordship? Your lordship, I would first like to read out the FIR filed by the informant that is in page number 12. Your lordship, sir, with due respect, I am the registered patadar. Your lordship, this FIR was filed by Purna Das. With due respect, I am the registered patadar for the land bearing DAG number 189 and patta number 44 in Revenue Village, Dhonipara Gaon, Circle Palakbari, Moza, Bordwar. The accused persons are not co-patadars of this land. On 12/11/25 at approximately 8:30 a.m., when my family and I went to the land to harvest rice paddy, we were assaulted at the site. The accused number 4 beat and stabbed my brother Sri Kondorpa Das with a rod. The accused number 5 caused a cut injury for my son Ujjal Das. Accused number 1 inflicted the cut upon my son Ranjan Das, which resulted in his demise at GMC. The accused number 6, Ratul Bharali, assaulted my nephew Green Mali with a rod. Therefore, this FIR is lodged to ensure that the necessary action is taken against the accused person as per law. It is the FIR filed by the informant, Your Honor, on 12/11. On the same date, on the same time, and on the same time, and second FIR was filed by us, that is the petitioner,
Pro Rukmuni Bharali. I would like to read out the FIR on her. With due respect, the aforementioned accused persons in a pre-planned manner.
Page number.
Page number 19.
Yes.
With due respect, the aforementioned accused persons in a pre-planned manner forcibly entered our land to harvest the standing rice paddy. When our family member attempted to stop them, they assaulted our mother, Nirola Bharali, tearing her clothes. The accused persons were armed with various sharp weapons, including a machete, axe, sticks, a spear, and a hoe. They assaulted my brother-in-law, Gulab Bharali, chopping off one finger from his left hand and inflicting grievous injury on other part of his body. Furthermore, they assaulted my brother-in-law, Mukut Bharali, causing a head injury which necessitated his admission to the hospital. Therefore, it's pray that kindly take all necessary steps in this matter as per law and take necessary action. Your Lordship, this is the FIR filed by us. Your Lordship, the relevant para in the petition, that is para number 5. We have explained in detail, Your Lordship.
No, it's okay. Now it seems that from the plain reading of both the FIRs that there was a land dispute between
Yes,
parties,
yes, Your Lordship.
and for which the occurrence took place.
Your Lordship, yes, Your Lord,
The
yes, Lord.
question is that one person died.
Your
That is
Lordship,
the
if
main
I
issue.
may, if I may add one more point, Your Lordship. Your Lordship, the informant have admitted this is our land, Your Lordship, because a title suit is going on regarding same land.
Everything understood. Yes, that also is going on. In your pay, you are the plaintiff there.
Yes, Your
That
Lordship. We are a plaintiff. It was filed by Nirola Bharali.
Both CD may be compromised. 283 and 280.
Your Lordship, one more humble prayer, Lordship. Your Lordship, your petitioner number Madan Bharali, the petition number 1 and petition number 5, Pranav Sarania. Your Lordship, although they have been named as a co-accused in the FIR that has been annexed in Annex 1, they have not been the participant in the alleged allegation.
Now, see, overall, it is a case of murder. We can understand their participation in which manner, because in a group they have come as per the allegation. So, forming a unlawful assembly or forming a group, they have come with sharp, with arm, the lathi arm, with the sharp object and all. And admittedly, there was an altercation or quarrel between two groups for the land dispute.
Yes, Lord.
It seems.
Yes, sir.
But what are their performance, how they are involved in the case, that we cannot see plain reading of FIR only. Obviously, there is no direct allegation of stabbing and all against these two.
Yes, sir.
So that may be a case, but without perusal, I don't think it is a big case. You are Mr.
Anvia.
Anvia. Hard Mr. Anvia, the learned counsel. Your name has not been reflected. Are you appearing for someone?
Your Lordship, I'm appearing on behalf of M. Kashyap.
M. Kashyap. Appearing on behalf of Mr. M. Kashyap, the learned counsel. And also heard Mr. P. Boddenpur, the learned petitioner PP, appearing on hearing both the sides. It is seen that the cross case is also lost by the petitioner side. Accordingly, it is felt necessary to call for case diary of both the FIR, both the cases. Number was asylum. Well, it can be listed. It's the ABI.
8-1 or otherwise, my lord, then after vacation it would be 19.
Yes, obviously after vacation.
19-1.
19-1 will do, or we want it
Your Lordship, before the Bihu vacation, Lordship. Around
for
the Bihu vacation.
Bihu vacation.
8-1 or 9.
Okay, 8-1. 8-1.
My please, Your Lordship. Madam, maybe pass back for that time.
May please, Your Lordship. Anticipatory bail application. Under the Assam Cattle Preservation Act, 30 kgs of beef was found in the house of the petitioners, my lord. No, at this stage,
He brought all this
30 kgs of beef, my lord. The allegation was that it was slaughtered
for his own consumption or for selling or for what?
No, their allegation is it was for selling, my lord. Our contention is that there was a social occasion for which the meat was procured, my lord. But at this stage, my lord, I will not bother your lordship because their disputed contentions are there. I pray that your lordship may call for the case diary at this stage. At the end of the day, the allegation is there that they had slaughtered. So,
Slaughtered. 7-1 can be
7th, my lord.
CTB court.
Well, this is also an anticipatory bail application.
Hmm.
Here, madam, this case was registered, a complaint was filed under that Railway Property Unlawful Possession Act, my lord. The lordship will find the complaint at page 12, my lord.
Page 12.
Page 12, my lord. The lordship will kindly note the date, my lord. This was lodged on 13/5/2025. I'll
Yes.
just give the gist, my lord. The railway police, my lord, they found 4 barrels, my lord, 4 drums, my lord, out of which 2 contain suspected petroleum product. So the railway police suspected that this was railway product, my lord, which was procured or stolen by these petitioners, my lord. Now your lordship will kindly come to page 14, my lord. In relation to the same allegation, my lord, an FIR had already been lodged, my lord, and that your lordship will find relevant portion at page 17, my lord. And your lordship will note that this is dated 11/5. So the complaint by the railway police, that was on 13/5. But prior to that, on 11/5, my lord, on the same allegation, my lord, these drums were found, my lord, containing suspected petroleum products,
That
my lord.
was filed by whom?
This was filed by, my lord, police from Kajalgaon, my lord. Kajalgaon police filed this FIR, my lord. Now, in connection with this FIR, the police had called the petitioners, my lord, and the petitioners had appeared before the police.
In connection with FIR of 17.
17, my lord. The police had called the petitioners. Petitioners had appeared before the IO. IO interrogated them, and my lord, they were let go. Now, at page 18, your lordship will find that almost 6 months after the lodging of the complaint, now railway police have issued a notice to the petitioners, my lord, to come and appear before the railway police, my lord.
After 6 months.
6 months, my lord. And the petitioners are otherwise ready and willing to appear before the investigating inquiry officer in this case. But the apprehension is that because the other accused persons in this case had been arrested. So this apprehension is there that if they appear, my lord, they may be arrested. Though they were not arrested in the Kajalgaon case, here they may be arrested. And otherwise, my lord, your lordship knows under that RPUP Act.
So from where you are saying that both the cases are of some same cause of
My lord,
action or-
same allegation, my lord, will kindly, I'll just read, my lord, in that case, my lord. Page 12, your lordship will kindly come back, my lord.
Yes.
May I read, my lord?
Hmm.
With due respect, I do hereby lodge a written complaint to this effect that on 10/11/5/2025, I, so and so, was detailed to perform duty as QRT party in charge of so and so, guarding and passing duty. On that night, one loaded so and so out of BRPL New Bongaigaon at 16:35 hours of 10/5/2025, and I, along with BRPL and Dangtol Station Duty RPF staff, safely guarded past the said train and out of Dangal Station at 20:20 hours after one another load BTP and so out from New BRPL New Bongaigaon. The English is, my lord, going here and there. I, along with BRPL and Dangtol Station Duty RPF staff, safely guarded past state train and out from Dongtol Station at 3:04 hours with all correct. After guarding and passing duty, I, along with the party, proceeded to barrack. On 11/5/25, information was received that some drum filled with suspected petroleum product kept concealed in dense bushes nearby so and so near Dangtol Station.
Here also it seems that on 11/5/2025.
Exactly, my lord. And here the allegation is of 11/5, recovery of these drums, my lord, in the area near the station. And your lordship will see at page 17 also, my lord. Same allegation, my lord. I have the honor to inform you that on 11/5/25 at so and so time, information was received regarding theft of petroleum products near Dangtol railway station, which occurred between so and so, so and so. The entire stolen products were reportedly concealed in a nearby jungle area. So same allegation, same date, this recovery was there. This was the prior FIR. This was registered under offences of theft, my lord, and Petroleum Act and EC Act. In this, we have already appeared before the IO. In the complaint now, after 6 months, notices have been sent to both the petitioners, my lord. And we are ready and willing to appear because in the main case, we have already appeared. But because the co-accused have been arrested, we have this apprehension. And your lordship will kindly come to page number 22, my lord. Some of the co-accused in this case, my lord, preferred an anticipatory bail application before this honorable court. 4 of them, my lord, and 2 and 3 got arrested, so they became infractors. But 1 and 4, my lord, they were granted anticipatory bail by this honorable court.
Yes, my lord, regarding this my lord, case, my lord, who were allowed, my lord, in that case, my lord, one person, my lord, may come to page 24, second paragraph. Lords Council appearing for the accused appellant submitted accused number 1 has already been granted bail by the Chief Judicial Magistrate. So in that case, my lord, police case already he was granted by the CJM court. So it is subsequent. Fact is that, my lord, when drums were found in the nearby bushes, my lord, police case was registered. But subsequently, when come to know that this railway, well, actually this oil was stolen from railway engine. Like the earlier occasion, I have talked with the IO, but now he already appeared in RPUF for first occasion is for first offense 3 years, subsequently 5 years.
So will appear, my lord.
But the fact is that some person, they are collectively some doing on. Some person has to buy and some person has to stolen because of this cycle is going on. The Tonda railway safety device from the engine, because engines are hauled in nearby station.
Oh, then only this.
Then they broken the lock, safety device and stolen the
petroleum product.
diesel.
Mr. S. Done it also. Parash, Lanet, Standing Council, and a friend. This is an application. Submitted by
I'm
Mr.
CGC.
CGC.
Yeah, railway.
CGC?
Central Government Council.
Oh. Lanet CGC. It is submitted by Mr. Parasa Dilan. Sorry, it's by Mr. Nawaz Dilan Council petition that putting of the present FI. Complaint, sorry. One FI was lodged by Kajalgaon PS, which is accordingly registered registered as Kajalgaon PS list number 73 of 2025 under section 303 subsection 2 317 subsection 2 317 subsection 4 and read with section 23 of the Petroleum Act, read with section 7 and 8 of
Essential
Commodities Act. So we further submitted that in both the FIR, the cause of action and the date of incident is same, and for the same cause of action, both the FIRs has been lodged initially by Kajalgaon Police and subsequently by RTA. But in the earlier case, that is on Kajalgaon PS case number, both the petitioner had received notice from the police, and accordingly they appeared and they were interrogated. The same. But subsequently, after 6 months of the registering of the case, one notice has been received by these petitioners from the RPF directing them to appear before the authority. Both the petitioners are, however, ready and willing to extend their cooperation in the investigation of this case. But as one of the co-accused has already one or two.
My lord,
two
were arrested.
Two got arrested.
Two got arrested.
Two got
Two got bail.
Yes, 2 persons have already got arrested in connection with this case. And hence, there is an apprehension of arrest, which the present petition has been filed seeking the interim petition. We further submitted other 2 accused persons have already granted anticipatory bail. Next, Mr. Parach done it. DGC submitted in this one. That you are saying that this is the this petroleum is your product, or what you saying?
From railway property they have stolen it.
That the allegations that the railway property has stolen the railway property, that is petroleum product, and accordingly the case was complaint was lost. However, he submitted that fact that they have already cooperated in the investigation in the other case. However, Mr. Paras insisted also for the list. Expert considering the entire facts and circumstances of this case. I suppose that interim protection may be provided. Okay, you'll be under interim protection. We are calling for the, it's called case diary or complaint, what it's called? It's report.
Otherwise, well, in the earlier cases. also-
Absolute was granted, madam.
No, I have nothing before this court. That's why I'm saying
No,
this
my-
only report may be called.
Madam.
Report. We'll be fixing on 22nd February, January. 22nd of January.
22nd.
Madam, will kindly reflect that complaint number as that RPF post that
RPF post in BQ, case number 04/20.
2020.
That is the case number, well, page 1. RPF post NBQ, case number 04/20.
Page 1, my lord, bottom.
Page
1, my lord.
Page 1 bottom. First item,
first item.
that is the case.
Silo, yeah. Okay, we calling.
मुझे क्लियर बोला जी
22nd of the
22nd
26.
May I please, your lordship? This AV is filed after the rejection of the AV filed before the Court of Sessions, Amingdam. This is regarding an FIR which was registered by the police itself. May I come to the FIR first? Page 19. To so and so subject FIR, I would like to report that around 3:10 p.m. of today, one source information received by the additional SP headquarters Kamrup that a gang of burglars, robbers who has committed burglaries, housebreaking by night at various Namgars, temples, house of people, and had taken away various puja copper items, had criminally conspired with the owner, manager, staff of Rhino Karai Factory. I am the owner of Rhino Karai Factory, godown located at Bhetamuk, Goripur, to covertly sell the looted copper and other items. It was also informed that the stolen items were covertly stocked there. Based on the input, a police team raided the premise and found huge quantity of temple Namgar copper items like Tilinga bell, Soria, copper plate, dhoti, etc. As per the seizure list, and the weight of the items runs in several hundreds of kilograms and valuation is around 15 lakh. It may be stated that the owner, manager, etc. in the garb of running a Karai factory were illegally a part of the burglar gang and receiving the proceeds of crime and disposing them off for financial gain. The detained manager, etc., could not satisfactorily account as to how temple Namgar items used for worshipping goddesses came to be stocked in a Karai factory. It is also suspected that they themselves may be part of the entire robbery gang and were physically present in the robbery burglary process. But if this complaint was registered by Sri Kailash Kumar Burman, who is Sub-Inspector of Police. Before that, the seizure was made prior to the registration of the FIR. And the seizure list is on page 15. I would like to show the description of the seizure articles. 1, 9 bag copper, each weighing 60 kg, is equal to 540 kg. Item 2, 2 bag copper, total weight 84 kg. 1 bag pitol miscellaneous, 66.5 kg. This was the items which were seized at the time of seizure. Lordship, may I bring you the actual seizure list is on page 17. So there are 3 items, 1, 2, 3. In the third list, item 3, he has added a modification as continue list enclosed. That means when the seizure was made, this list was not prepared. This seizure has been witnessed by 2 independent witnesses, Rahul Ali and Devojit Das, and countersigned by the circle officer at the bottom of the seizure. So now they have prepared a seizure detailed list of seizure. Those are counted from serial number 4 to 26 on page 18. The type portion is on page 16. So out of 66 kg pitol items, items 16, 17, 19, 21, 23, 24, 25. These are item number 16, Mandir Pitol Bell 3 numbers, School Pitol Bell 1 numbers, Mandir Tilinga 9 numbers, Mandir use Pitol Saki 4 numbers, Dhupdani 2 numbers, Shivlinga 1, Sankhya. That means roughly if we weigh it, it will not more than 5 kilos. Out of 700 kilos seizure, only these were the Mandir items. So, and my concern is Rhino Karai factory is a recycling unit of old waste materials. So when we produce
Do you
finished
think
goods,
those the mandir or namgar items are the waste material?
no, there were no Mandir items.
These are cannot be considered as waste material. Na?
No, my lordship, these are
India before
items
portion
often
there.
we procure items from the
So
retail.
why you have procured these things? These kind
No,
of
we have not
items?
procured
These are
this.
not the waste material.
No, this
Can it
Mandir,
be
this
considered those puja
Fir-
items
first
as
of all,
waste material?
first of all, these items were not seized by us. It was added in an additional seizure list. Secondly,
Yes, bought a Korean.
Well, prima facie, it seems that his custody information is necessary. All those items.
He is receiving,
Yes.
not this is the first time. He is
Yes.
receiving this stolen property
Yes.
or the property through burglary and all. He
Yes.
is receiving since several years and all. Now he is running that business.
Yes.
We need the period.
lordship,
It's not a case of this thing.
lordship,
Otherwise, my prayer.
at best, the allegation against me, it will be of 372, punishable after up to 3 years. I am the owner.
Receiving this, you are habitual if
Yes.
you're receiving, that will come another section.
No, lordship, I am ready
You are
to, because I am not,
habituated.
I am not even named in the FIR. I am not
Yes,
being,
but the
I am not
manager
being
section,
issued,
how can you be named in?
I am not
You are
being
the
issued
manager of that
issued the
factory.
notice. Lordship, I am not being issued the notice
You are the
of
manager
FIR.
of that Karai factory where from those things were recovered, and you are saying yourself, you are saying you are this waste material are going to process and all, making all
So,
these things. Are you
lordship,
doing?
lordship,
So you're receiving all these
sir,
stolen
lordship, I would like to
property,
explain the code,
kind
how
of
it
the
came to,
burglar or the decades,
how it
and
came
then
to
you are
me.
receiving all this property since
Lordship, I
several
would like,
years.
lordship,
You
I
are
would like
lost
to,
case. This is the first time with a good, without any
lordship,
intention you have received. You are
some,
receiving. You are receiving that
lordship,
property.
lordship, we
Okay,
don't,
we are calling for a case diary when it can be possible.
Well, my prayer because Lordship, considering all these facts, already trial court has rejected.
Yes, it has already been
At this
rejected.
point of time, already trial court has also observed that custody interrogation of the petitioner is very much necessary.
no, not
After
trial
taking
court,
all these
it was
notes-
sessions court.
So my prayer before Lordship, in fact, my lord, to reject this and
Outrightly.
Lordship,
Okay, then we'll give a chance.
Lordship,
Let the sit. Will this diary be produced?
lordship,
We wait. Who knows?
so lordship, I would
Knowledge
like
of
to
this
submit,
Bihu Mission. It's okay. So
lordship, I would like to submit,
21-1.
lordship, I would like to submit that this,
21-1-26 for this.
lordship, I would like to submit that these items are procured from the retail utensil sellers. They collect as,
The allegation is not that, na? Allegation against you that you are receiving
yes,
those
that is,
puja
I want to,
property, Namgar
I would like
property,
to
all
join the
this.
investigation and clarify how the items are sourced to me. So,
Yes, yes. Okay, we
whatever,
are calling for the case diary on 21st of January.
lordship, in the interim, maybe,
No, not kind of. It's not a case of any interim at all.
oblige.
May it please your lordship. It was an anticipatory bail application. Earlier it was rejected by your lordship. But subsequently was there some development, the new
Is
ground
there
is,
any new development?
yes, my lord, the co-accused, almost all of the co-accused, my lord, they have been granted, some got arrested, they were immediately granted bail, and others were, my lord, granted anticipatory bail by the Learned Sessions Court. But because this bail was rejected by this honorable court, so because of judicial discipline, we could not approach the Learned Sessions Court. Otherwise, others have been granted.
Considered case or
No, no, my lord. My lord will find the FIR. Your lordship may remember this also at page 12, my lord. On the day of Eid, my lord, there was some allegation that some persons had thrown, my lord, beef near a temple, my lord. That's a different case, my lord. Subsequently, an altercation, almost a riot kind of a thing happened between the two communities in that area. The altercations and fight took place. Police administration also had to intervene, my lord. So that is the allegation that your lordship, I'll just read the relevant portion, my lord. Page 12, my lord. Starts with second paragraph, my lord. Today in the morning, cattle flesh was found near Soni Mandir of so-and-so when a group of nearby people of Borpukuri protested at around 8 a.m. regarding the throwing of cattle flesh near the mandir seeking action against the culprit. A big group of miscreants gathered at some distance from there. During that time, one Subodh Das was proceeding with a customer in his auto near Bhuyapoti. The miscreants beat him up with fists and blows as well as lathis. The miscreants also tried to topple his auto. With great difficulty, he escaped from there. Thereafter, one Nimai Sutrodhar was proceeding in that area, the miscreants threatening to kill him as he belongs to Hindu community. The miscreants also criminally intimidated him, and when they advanced towards him, he ran for life from there and informed police who were at some distance. Initially, a police party proceeded towards the group of miscreants. The miscreant group also advanced towards the police party with lathis to assault and deter the police party from doing their lawful duties. So this is the, my lord, allegation. Now, your lordship's rejection order, the lordship will find at page 17, my lord. Your lordship, after going through the case diary and finding some materials against the petitioner, my lord, there were two petitioners in that case, my lord, Wahid and Gulzar. Now only Wahid is here, my lord. Your lordship
What about
rejected.
the Gulzar?
Gulzar has
already
not
on
come,
bail.
my lord.
Oh, not.
Gulzar has not come, my lord. Others have been granted. So your lordship rejected. Another bail was filed at page 20, but this was withdrawn, my lord.
Subsequently withdrawn.
Withdrawn, my lord. Now your lordship will come to page 21 onwards, my lord. So given all the orders, 21 Amir Hussain, my lord.
Yes.
Amir Hussain, this was 483. And your lordship will kindly come to page 22. He was initially granted interim bail, my lord, on 1/7/25. Subsequently, his bail was made absolute. Thereafter, page 24, my lord, Anwara Begum. Here also, my lord, bail granted, page 25. Then page 27, my lord, Mujibur, Tazmina, Azim, Kamir Hussain, Moinul, Ainul, and Ali Ansari. Again, my lord, they were granted bail. Hereafter, page 30, these are all anticipatory bails, my lord. Roshanara Begum, page 31, anticipatory bail granted. Page 33, my lord, this is Abdul Aziz, my lord. 482, my lord. Again, he was granted interim bail on 15/7, page 34, my lord, then made absolute. Then page 36, my lord, Monuhar Ali. Page 37, my lord, interim on 4/7 and then absolute. And page 39 is, my lord, Rafiq Uddin, my lord. He was granted, again, he was also granted, my lord, anticipatory bail, my lord. And in relation to the original case, my lord, which was regarding that throwing of beef, my lord, at page 41, this petitioner, my lord, he was granted anticipatory bail by this honorable court. All of these were, my lord, not placed in last time government. So considering this aspect, my lord, at least interim may be granted so that I can appear and participate in the investigation. Here in this regarding the other bail petitions, my lord, in page number 21, regarding, my lord, one Amir Hussain, learned counsel for the accused petitioner has said the accused is a sick person, as his lumbar spine has ruptured and he was continuously so on that ground, my lord, he was granted bail. And next, my lord, only Anwara Begum is BA, my lord. Only after, my lord, and thereafter, my lord, regarding other accused persons also, my lord, BA, my lord. 27 BA, but from page 30 onwards, all AB, my lord. Then next, my lord, in the item number 36, my lord, one accused person, Manohar Ali, was allowed to go on bail because he is not an FIR name accused, my lord. And there are no any allegations against him. He is also on that ground, saying all the after paying the CD. This is, my lord, I will get updated. This is an FIR of June, my lord. One person was granted bail because of medical reason. Others, my lord, the lordship has seen, my lord, AB has also been granted. It's a June FIR, this is December, my lord. Case is also pending because this petitioner has not been either been apprehended, he is not on bail. If some protection is given, he will appear, at least the lordship will allow him to participate in the investigation. At least it will go to some logical conclusion. He is already on bail in the other case, main case.
Mr. Desna. Report. is some Mr. Ramos that he presented in this second, the subsequent bail application after revision. His earlier bail application dated
Dated, my lord, 31/7/2020.
1/7/25. 25. He submitted the earlier bail application. And however, he submitted one more application which was accepted withdrawn by the petition. Mr. Ramos further submitted that at the time of filing the bail application, some the bail orders passed against the other co-accused persons were not brought on record, but the other co-accused persons have already enlarged. Some are on anticipatory bail and some regular bail. All the orders have been annexed along with the petition. It is submitted and Mr. Nawaz that one anticipatory bail application was also one anticipatory bail application of a co-accused has also been granted by this court by this order dated 29/7/2025. AB number 403 of the Mr. Nawaz further submitted that the accused petitions are ready and will extend his cooperation with the further investigation of this case. He has granted with the privilege of readiness. Next one, Mr. Portable PP submitted in this regard that his earlier bail application was rejected. The period of the case died. Also, the order which have been annexed along with the present petition seems that the sum of the petitioner's bail prayer is considered only considering the period of detention, and in one explication the period of the cause of the health considering the health condition, the bail was granted. Accordingly, Mr. Portable raised objection and submitted that his diary may be called for to know the progress of the investigation. During this submission made by this court is of opinion that the interpretation may be provided to the petition till the receipt. You'll be under it.
Deeply obliged.
We're fixing it on 22nd of
Well.
Jan.
Deeply obliged.
May I plead your lordship?
Yes.
Lordship, FIR is page number 10, your lordship.
Page number 10.
10. Lordship, actually matter regarding cattle preservation act, your lordship. May I read the FIR? I understand that is so Orup Das presently posted as at Mikir Vita PS would like to lodge this first information report regarding an incident of illegal transportation of cattle with extreme cruelty, which came to my knowledge on that so and so. On the said date, at about 8:30 p.m., the police staff of Mikirvita police station had ambushed a vehicle on Mikirvita Morigao road near Saraibahi, based on the secret information. During the ambush, a vehicle bearing registration number so and so was intercepted. Upon physical verification of the vehicle, 30 numbers of cattle were found being transported in a very cruel and inhumane manner, causing unnecessary suffering to the animals. During on-spot inquiry, 3 persons present in the vehicle failed to produce any valid documents related to the transportation or ownership of the cattle. The driver of the vehicle fled from the spot, which strongly indicates that the cattle were either stolen or dishonestly received, transported, or illegal. The FIR itself mentioned that 3 persons namely in the last page number 11, number 1 Sayadur Bastur, and MD Dildar Hussain, number 3 Jalaluddin. These three persons inside the said cattle carrying vehicles, Your Lordship. I am number 4 Mehboob Alam, Your Lordship. I am not in the said vehicle, Your Lordship.
You were absconded. What to do? You absconded. You were
I'm
the
not.
driver of the vehicle and you got absconded.
Yes,
That's why you
as
could
per
not be
FIR, but
absconded.
I am not in the said vehicle, Your Lordship.
You were there, you absconded.
No, Your Lordship.
Keeping the vehicle there, 3 persons were there and you got you absconded.
No,
That is,
Your
you could
Lordship.
not be apprehended. You were there, you were very much
Lordship,
present there.
FIR dated 4/12/2025.
Yes.
After 4 days, the police issue notice under section 35 subclause 3 of BNS, that is page number 19, Your Lordship.
Yes, appear. Why don't you appear?
Lordship, some interim protection may be given.
No, why
I will
didn't you
appear
appear?
before the
I'm asking why didn't you appear?
Lordship,
Because
I have stated in page number 4, Your Lordship. There are 4.
what to do for what?
And petitioner number 2 is my brother, Your Lordship. He is not in the FIR name accused, Your Lordship. Munjur Ilahi. He is not in the FIR, Your Lordship. So some protection may be given, allow him to appear
Carry
before
those
the.
cattle in such a inhuman manner, you don't feel anything.
I am not, Lordship,
No,
may I
why
read?
are you carrying the cattle is in such a inhuman?
Lordship, kindly come to page number 4. There are 4. I have stated.
Whatever. Why you have? Hmm? Why you carrying those kettles? In
I
such
am
a
not
manner?
carrying the
Cruel.
cables. I am not in the said car, vehicle, Your
No,
Lordship.
you were there. You were the driver. You were the person. You were the driver. You absconded, na? That's why you could not be apprehended. Otherwise, you were there. You were the driver. Others are bichara handyman. You were there.
Lordship, this 4. May I read, Your Lordship?
But at this stage, we do not know these are stolen one or how they procured. These are not.
Lordship,
You don't have any.
kindly.
Huh?
Page 4. May I read, Your Lordship?
This is your plea. This is your case. But what FIR says is that you were there.
Petitioner number 2 is not named in the FIR accused, Your Lordship.
Why you are apprehending arrest? Why your apprehension of arrest is there for the respond number 2? Okay, the petitioner number 2. Why? You are not there. You are not the FIR named accused. How you are related?
Page 4, Your
No,
Lordship.
how you are related?
After issuing the said notice,
Notice issue.
Lordship,
Let him
the Mikir
appear
Vita,
before the pardon, Mr.
M. Hussain.
Here,
M. Hussain, Your Lordship.
M. Hussain, and constituted petitions. Considering the submission made by Constable made in the FIR, I find it difficult to extend the privilege of interim dispute with present petition, the direction. Okay, you will be under interim protection, appear before the IO and cooperate with the investigation within
Obliged.
7 days. Okay,
Obliged.
we are listing your case on 21st of Jan 2026.
Obliged.
Appear within 7 days.
May I please your lordship, some personal difficulty of my senior, kindly matter may be taken on Thursday, lordship.
Sorry. Thursday cannot be.
Then
Because many
Friday,
matters have been fixed on Thursday.
before vacation, lordship.
Sorry, we cannot.
Then kindly matter may be fixed on Act 2. You will come
At 2. We'll
May I please your lordship? This is an application under section 482, your lordship. Page 14 is the FIR, your lordship. Lordship, I, Sri Rohit Agarwal, would like to lodge an FIR regarding an incident of looting case that took place on 11/11/2025 at 2:55 p.m. while his said vehicle was traveling from Dibrugarh to Tinsukia through NH 37 with Ramesh Kumar Agarwal and driver Arjun Setri. While returning from Dibrugarh in between Hatiali railway station and Dicom, some unknown miscreants intercepted the vehicle and looted rupees 26,63,000 by threatening the driver and Ramesh Kumar Agarwal with dagger and pistol. The said amount was collected by Ramesh Agarwal on my behalf from GS Traders owned by Bijoy Beria, located at Marwari Petri Dibrugarh. After collecting the cash, Ramesh Kumar Agarwal is returning to Tinsukia on the said vehicle when the incident occurred. The miscreant forcibly took the cash and fled from the spot immediately after committing the crime. Both driver and Ramesh Kumar Agarwal were threatened but managed to escape without physical harm. Now, your lordship, in this connection with this case, the driver who was driving the vehicle, he was arrested, your lordship. Your lordship will get it at page 18. Arjun Setri, your lordship. He is the driver, your lordship.
Is the driver or the handyman?
He was the driver of the vehicle, your lordship. And your lordship, what has happened, your lordship, in this case, 4 persons has already been arrested by the police. And one of the arrested person, his name is Madan Para Chetri, your lordship. He, your lordship, hired my Swift vehicle, your lordship, on that day, and I dropped him in Dibrugarh, your lordship, at around 11 a.m., your lordship, in the morning. And I have dropped him and I came back. And in fact, your lordship, the incident took place at 2:30 thereafter, your lordship. And now, therefore, since he was
Dropped him where?
at Dibrugarh, your lordship, at that point where, your lordship, this incident took place, your lordship. He took it on hire, your lordship, and on the basis of that, your lordship, police is now also searching for me, your lordship. That's why I am before this honorable court, your lordship. And otherwise, if your lordship would see in the forwarding reports, my name has, in none of the forwarding reports, my names have been cropped up, your lordship. But your lordship, I am apprehensive that, your lordship, one of the accused has hired my vehicle, your lordship, and I have driven it, your lordship. Therefore, I have made a categorical statement that your lordship will kindly come to para 5 of my petition, your lordship. That the petitioner begs to state that the true facts of the case is that the petitioner is the owner of a Swift car bearing registration number so and so, and by providing ride service to the said vehicle, he earns his livelihood. On 11/11/2025, Madan Para Chetri inquired with the petitioner as the charges of providing ride to Dibrugarh, to which the petitioner asked for rupees 7,000, and only from Madan Para Chetri. Accordingly, at 8:30 a.m., Madan Para Chetri and the petitioner left for Dibrugarh at 11 a.m. After reaching near 80 Road, Dibrugarh, Madan Para, they asked the petitioner to drop him there and paid the fare of the ride to answer to the petition. Now, on apprehensive, and I have come before this honorable court, your lordship, may call for the case diary, your lordship. And if your lordship allows me to participate in the investigation, your lordship, by protecting me, your lordship, and if your lordship finds something ultimately in the case diary, your lordship will reject it, your lordship. By my instruction is very specific to that extent. This is my case.
22, madam. If you there are count of the comfort, where is it? There are the arrested accused person Dipankar Sekia led the police with confirmation from where 3 lakh case amount was recovered and it was leading to recovery. This case amount was received by the arrested person Dipankar Sekia after the robbery. A total amount was divided between him and other accused persons, Madan Para Setri, Raju Setri, and Onting Lam.
Petitioner.
Also, the white color bolero hearing was recovered from his.
It is his
Then
position, not my position.
It was the therapy, all of them divided the Recovery
I have not, that has not been divided, Your Lordship.
in the one single lump
Clearly stated, yes.
presently.
Lordship. Lordship may call for the case there.
We're calling for case diary.
Lord.
City. Wait. What? Vishma did I call for case diary? We obviously after vacation, you want immediately after vacation.
Lordship may fix it. 6, 7, 8. Your Lordship.
We have fixed it. 7 of January.
Lordship. Diploma.
Yes, have you gone through the record?
Yes, Lord. My lord, in this case, Lordship, the petitioner was arrested on 2025.
22
2025. 20th of February.
2002.
Yes, Lordship. 20th of February. As on date, Lordship, he has completed 300 days. That is approximately, Lordship, 10 months.
Yes.
In as much as, Lordship, 5 persons are there in the FIR and charge sheet, and Lordship, 4 are already on bail.
Out of 5.
Here, Lordship, my prime ground on which, Lordship, I am seeking bail is that the possession of the petitioner, nothing has been recovered. He was arrested only on the basis of the statement of the co-accused. In the charge sheet also, there is nothing specific as to what role has been played by the petitioner is mentioned. And that is mandatory as per the judgment of the Honorable Apex Court. I will place that. Another is that, Lordship, when the charge sheet was submitted, on the very first day,
Just a second. When is charge sheet was submitted? Charge sheet was submitted on when?
charge sheet was submitted on 31st of March 2024.
31st of March.
Charge sheet. Cognizance was taken on, Lordship, 5/4/2024. Charges are yet to be framed as per the last report. And Lordship, when the charge sheet was submitted, on the very first day, without issuing any summon, NBW was issued. Lordship may kindly come to the FIR at page number 20.
Page number?
20.
Yes.
This is to inform you that a secret information was received by me, so and so. A large quantity of narcotic drugs are kept concealed inside a Alto vehicle bearing registration number so and so. My lord may kindly come to the third paragraph. On reaching the spot, I laid down ambush at so and so, wrote in front of the house of so and so. At around 1:50 p.m., I noticed the vehicle as described by the source approaching towards me. My lord may kindly skip the middle part. During search process, the following items were recovered and seized. Recovery is, Lordship, at 8,000 Yaba tablets. My lord may kindly come to the next page. Second paragraph. After completion of all the formalities, the police party departed from the PO at 4 p.m. and returned to the police station so and so along with the seized item and apprehended the persons, namely number 1, Miftarul Haq, Asrarul Haq, and Abdul Manaf, and handed over the seized drugs to so and so. Now, my lord, this is very important. It is also to be noted that during interrogation of the driver Miftarul Haq at PS, he revealed that on 31st of December 2023 morning, Niarun Nessa, that is the wife of the petitioner, of so and so, gave him the narcotic drugs to deliver it at so and so area. He also revealed that Asauddin and Mutir Rahman few days ago brought narcotic drugs from Mizoram area to sell it at different locations of Swans. This is the petitioner, my lord, Asadu. As per the statement of this accused number one, arrested accused number one, the petitioner few days ago brought some narcotic drugs to sell in the near area. On the basis of the new input, I along with the police personnel headed to so and so at around so and so. I along with detailed staff at so and so, so and so, so and so, and then finally apprehended Motiur Rahman from his house. The another person, lordship, whose name was said by the arrested accused, he was apprehended on the very same day. On arrival,
Your name is Asaruddin.
Asaruddin. So, lordship, there are 6 persons named in the FIR, and my name is at number 6. Asaruddin. This is the FIR, lordship, and as per the FIR, everything was recovered from the Alto, and in the Alto, 3 persons were there, and on the very same day, another person was arrested. Now, my lord, may kindly come to the charge sheet at page number 39.
Page 30?
39. Charge sheet was submitted on 31st of March 2024. Lordship, may kindly come to page number 47, paragraph number 21. Page number 47.
Yes.
Page 47, 21 paragraph. It is therefore prayed that Honorable Court may take cognizance of offence committed by the accused persons as mentioned in para 17 above and issue process of the said accused to the said accused persons to stand trial in the court in accordance with law. Since FR is being submitted, it is required to accept the same. It is also requested to pass necessary over, perhaps it would have been ordered for disposal of the seized so and so. Lordship, this is the charge sheet, Lordship. In the entire charge sheet, there is nothing. And Lordship, another thing is that Lordship may kindly come to page number 43.
Hmm.
43. Accused number 6.
Accused
Name
number?
6. The first one, and then Lordship may kindly come to the next box.
Hmm.
Accused number 6, name of the petitioner is Asaruddin.
Hmm.
Nothing is there. What role he has played. In the entire charge sheet, nothing. Now, Lordship may kindly come to page number 56. (50) 55 first. Then my lord may kindly come to page number 50. 55. Order dated 5/4/2024. Charge sheet bearing number so and so dated so and so along with the case diary of the instant case has been submitted under section so and so against the accused persons, namely so and so so and so. And absconder Asaruddin. Let the same be tagged with the instant case record. Rest as before. My lord may kindly come to the next order. 10/4/2024. Accused so and so so and so so and so are produced from the jail through video conferencing. In view of charge sheet being submitted in the instant case, issue NBWA against the accused so and so. Very first day, NBWA was issued against me. This is the factual backdrop of the case, Lordship. Admittedly, nothing was recovered. Admittedly, I was arrested only on the basis of the statement of the co-accused. And so far as the bail orders are concerned, Lordship, all the bail orders are here. Though I'm not taking those ground as because, Lordship, all the person were granted bail primarily on the ground that, Lordship, grounds of where arrests were not found. So I'm not going there. He was arrested on the strength of NBWA. That proposition will not be applicable in the case of the present petition. And in this regard, Lordship, I would like to place one judgment, Lordship, that is order dated 17/11/2025, passed in PA number 3398 of 2025. This is a case, Lordship, where the person was arrested only on the basis of the statement of the co-accused. My Lord, may kindly come to paragraph number 3 and 4, page number 2. Quote, accordingly, aforesaid person was arrested and contrabands were seized and police registered so and so, so and so. During the investigation, the aforesaid accused, namely so and so, had made a statement that he was carrying the contraband drug for delivery to the accused applicant. On the basis of the aforesaid statement, the accused applicant was arrested by the police on so and since then the accused applicant was behind the bar. Now, my lord, may kindly come to paragraph number 7. Dear Lordship, 7 I am referring to as because the judgments are there on which I am also relying. Number 1, Tufan Singh, and then Lordship Pallu Levit Ahmed, and P. Krishna Mohan Reddy, and Bharat Chaudhary. These are the judgment, Lordship, that those were relied in this case. So, my Lord, may kindly come to paragraph number 11. 11. It is apparent from the record that investigation in the incident case is still going on and charge sheet in the matter is yet to be filed. However, except the statement of the co-accused. Even Lordship, my case is more better as because charge sheet has already been submitted. Co-accused so and so, no other evidence alleging the accused applicant of his involvement in the aforesaid seizure of the contraband substance would be found in the record. In view of the judgment that have been relied by the learned counsel appearing for the accused applicant in the instant case, it is a settled law that a confessional statement recorded under Section 67 of the NDPS Act 1985 will remain inadmissible during trial of the offense under NDPS 1985. In view of the aforesaid position, it appears that there is no admissible evidence against the present accused applicant on record as of now to justify his detention and to invoke the embargo of Section 37 of the NDPS Act 1985 against him. Accordingly, Lordship, bail was granted. Well, though, Lordship, I am not referring all the other judgment, Lordship. One judgment which is very relevant, Lordship. Lordship, may kindly allow me to place that judgment. Let me kindly come to paragraph number 53. This is Lordship Krishna Mohan Reddy by the Honorable Apex Court of Appeal. Paragraph number 53, Roman clause 4. Where such a police statement of an accused is confessional statement, the rigor of Section 25 and 26 respectively will apply with all its vigor. A confessional statement of an accused will only be admissible if it is not hit by Section 24 or 25 respectively, in the tune with the provisions of Section 26, 28, and 29 of the Evidence Act respectively. In other words, a police statement of an accused which is in the form of confession is per se inadmissible, and no reliance whatsoever can be placed on such statement either at the stage of bail or during trial. Since such confessional statements are rendered inadmissible by virtue of Section 25 of the Evidence Act, the provision of Section 30 would of no avail, and no reliance can be placed on such confessional statement of an accused to implicate another co-accused. Well, so far as the
Just last year something.
yes, this would be last lot. My lords, may kindly come to paragraph number 31. It starts from 26, Lordship. I am relying on 26 to 31. I am reading only 31. As to whether, Lordship, the role played by the accused person has to be mentioned in the charge sheet and how. Paragraph number 31. Therefore, my lord got it. Therefore, the investigating officer must make clear and complete entries of all the columns in the charge sheet so as to the court can clearly understand which crime has been committed by which accused and what is the material evidence available on the file. Statements under section 161 of the code and related documents have to be enclosed with the list of witnesses. The role played by the accused in the crime should be separately and clearly mentioned in the charge sheet for which the accused or for each of the accused persons. In this case, Lordship, nothing that sort of is here, Lordship. Lordship, my humble submission is that, Lordship, the accused person is there behind the bars since last 10 months. And Lordship, nothing was recovered from his possession. The judgment, Lordship, I have already relied on. Considering all this aspect, Lordship, may I pray for bail, Lordship, with any condition. He is a local resident. I'm not reading anything, Lordship. Just I'm placing two more judgment. I have highlighted the paragraph, Lordship. Bharat Chaudhary and Kallula Bhekar.
That already, yeah,
Those are
that
already
is
there.
already
Just I'm furnishing the copy. And I have marked the paragraph.
My friend has already said about the action of here. I have a strong objection, my lord, for granting bail at this stage, my lord. Here, in the last chapter, the lordship was to call for a report, my lord, whether any witness examined or not, my lord. Here, as per report, my lord, charge is yet to be present. It is not yet, my lord, due to the absence of found out. Here, but if we found from the FIR itself, it reveals that, my lord, all of them are interrelated, my lord. Each person has here near Nessa is the wife of President Krishna, from whom it was also recovered for her statement categorically stated it was taken by her husband Akhtaruddin from Mizoram. And driver, my lord, Mr. Hawk, he also in his statement categorically stated that he was participating in Mizoram. And Akhtaruddin, my lord, he is the, my lord, one of the mastermind, my lord, when he purchased from Mizoram, my lord. Some of portion was given to Motiur Rahman, one of the accused person, my lord. The statement of the Motiur Rahman, my lord, is that he has taken second number of Bangladesh, my lord, and two of them he received kept for himself, my lord, to sold as per statement of the Motiur Rahman. And Motiur Rahman, as read and searched in the house of Motiur Rahman, my lord, was recovered. Document and the my lord, seizure list, my lord. 2 numbers of packet wrapped with color paper, which is that was recovered from the possession of the accused person Motiur Rahman. In the statement of the Motiur Rahman, it is categorically stated. I have taken out there. And one important thing is that after then dealing in his investigation, he is not cooperating with the investigation. He was declared as by the industry. And after searching matter, he was NBW was by the court below, and only on the strength of NBW he was there. Only on the strength of NBW he was there. During his investigation, he is not cooperating with the investigation agency. And from the my lord, a scanned copy of a record, my lord, it reveals that he is very much involved in this case. And he is the main peddler, my lord, who is when he passes it from the Mizoram and and distribute in different parts of the different agencies or different person manner to different places. It was revealed from the statement of the manner other co-accused, although it is relevant or not relevant is the different matter, but from the statement manner. For the investigation purpose, they are relevant, their statement is relevant for the and from the statement of the Motiur Rahman manner, I have from and when he lead and sold, several items were recovered from his matter possession. And My submission is here that my lord, ours is not yet, at least he is not my lord involved in this case, my lord. He may get details from the research from the my lord, side. And other witnesses, my lord, 10 witnesses in the charge sheet, my lord, and only three. And next date is fixed on 28/11. That is over, my lord. My humble submission is this is the original plan, my lord. And for that purpose, lordship will have fulfill the embargo of section 37 minus the commercial condition. Embargo of 37 minus, and at this stage, as the charge is not yet minus, it may not consider that. And from the record, it reveals they are involved, all of them. This is the organized plan. This is my submission.
Yes, can copy.
Right.
Pass it.
Right.
You mark the paras. You have marked the paras.
Yes, yes, Lordship. I have already marked the paragraphs, Lordship. Lordship is reserving the judgment or Lordship may
No, I passed today only.
highly obliged.
Just have peruse the record.
Yes,
that's
yes,
why-
Lordship may kindly go through. Highly obliged.
Here, case there is notice.
Is the person is on interest? No. Last occasion or Achana, he was present. And plan appears on call for the petitioner. Also, it is submitted by Mr. B. Sharma, the Application PP, CD number. Issue reminder, listing matter according after vacation as on 21/01/2026.
My pleasure. So though the matter has come up for admission, but the respondent number 2 has not been reflected. We were asked to serve a copy and we did, Lordship, as per the order dated 1/8/25. We have served the copy
1/8/25.
to the Office of the Government Advocate, Government of Assam.
There is the informant is the deputy commissioner. By name, his name was reflected. That's why.
So we had served the copy.
So you are not going to represent him?
No, Lordship, the Office of the
Office of the government.
This is the copy served, the receipt. So their name may be reflected because the name is not reflected. Nobody has. Yes, served it.
So
now.
he is going to represent by GA Assam.
Yes, ma'am. Because this, that
But
is,
otherwise, you have already served the copy.
yes, Lordship, this is the receipt. The office we have served. The GA Assam may be reflected and it may come up for admission. Trial court record is already received.
Heard Mr. P. Chaudhary, the Danit Council for Petition. Heard Mr. P. Submitted by Mr. Chaudhary in person to order dated 1/08/25. The copy of the petition has already been served in the office of the GA Assam. But the respondent of the evidence and accordingly submitted that the registry may be directed to reflect the name of GA Assam. Next, in view of this, the registry is hereby directed to reflect the name of GA Assam. And the matter may be accordingly listed for admission follow after the petition. Want any fixed date here or after vacation?
The date may be kindly fixed up.
22nd of January.
Lodge. The interim may kindly be continued.
Interim was there.
Lot.
Interim be continued till next year.
Deeply obliged. The receipt will be part of the record or I'll be.
Yes, yes. It's not part of the record for you. The By receipt of the receipt submitted by the land accountant for the petitioner from the office of the GA Assam may be kept as a part of it.
Briefly, okay.
60. May it please your lordship. Your lordship, Mr. A.K. Bhinia appears in this matter. He's on legs. Kindly take this up after some time. He'll be here in 15 minutes, 10 minutes.
Number four, whom I have been appointed as the so it's the government advocate or the
Oh, inspector of police.
By name, he was the informant of,
by name.
he was the informant of the case, lordship.
Which date? By which date it was appointed you as an amicus?
2025.
Not yet.
The service report was not there, na?
Lordship, this was the service of notice upon the respondent number 2 is
Complete, lordship. That is right.
that was reflected in the order, but none had appeared for him. Therefore, I was appointed as the I have a problem, but just that I have not had any communication. The so from the law firm.
Otherwise, matter is totally on law file, lordship. Very limited issue, lordship. Nothing against him or very limited issue, lordship. Whether the learned court below can take cognizance without previous sanction. Some previous is used in the okay, lordship.
No, it seems to be obviously it's up on the law point only the matter is raised.
Only purely
So,
legal.
by name he made as a respondent.
Not
So during that period, most probably he was working in that
that
capacity.
police station, lordship. And
So,
otherwise,
and
lordship,
the court had already passed an order appointing you as an amicus. So you may proceed.
lordship, lordship.
I just want to appreciate it.
Look, very limited issue is involved, lordship. FIR was lodged by the opposite party number 2. Page 14 is the FIR, lordship. I am not on the merit of the FIR, lordship. Page 14, annexure A is the FIR, lordship.
Yes.
And then after lodging of the FIR, lordship, charge sheet was submitted, lordship, under section 505, subsection 2 of IPC, lordship. Charge sheet was filed, lordship, on 30/11/2023, lordship. After filing of the charge sheet, lordship, learned court below, lordship, taken cognizance on 16 to
Just a second. Charge sheet was filed on under which section?
30 30/11/2023.
No. Under which section?
Under 505 subsection 2, lordship. 505(2).
5 subsection 2. IPC or BNS?
IPC, earlier law.
So thereafter, the cognizance also taken.
Cognizance taken. On 16 to 2024, page 28 is the order, lordship.
Cognizance taken on which day?
16 to, lordship.
16 to 2024.
24, lordship, under section 505 subsection 2, lordship. Our limited, lordship, prayer is that, lordship, the learned court below cannot take cognizance, lordship, without previous sanction of the government, lordship. Term previous is mentioned in section 196 1A, capital A of the CRPC, lordship, earlier CRPC. That is the, lordship, limited issue, lordship. And This, in this matter, Lordship, section mentions about previous sanction. That is not the sanction
You have,
maybe.
you have annexed here any
Lordship, I may
order of
read
sanction?
section 196 A1 capital A, Lordship.
No, order of sanction you have annexed here.
Lordship,
Is there, you have annexed the order of sanction, previous sanction, or there is no sanction at all?
no section at all, Lordship.
Acha.
And in record also, Lordship, nothing reflected in the order also, Lordship. And Lordship, only 3 witnesses are there, Lordship. Case is at the evidence stage, Lordship. There is no stay also, Lordship.
Conflicting matter, hypothetical matter, good for it, and open already he did matter, good for also open. For also receive matter. For hearing matter, admission hearing.
Then interim may be granted. Only 3 witnesses, Lordship. At the evidence stage, Lordship. In the meantime, Lordship, he might be convicted, Lordship.
Stage 2, I cannot grant granted. Eddie, what is this stage? Whether any, this evidence already started in this case or not?
PW1 was called for, Lordship. He did not appear, Lordship.
So in the very first occasion or the next, otherwise also you did not pray for any interim?
Earlier, it was prayer for interim, Lordship. Interim prayer
It's
is
not
there.
granted then at this stage, it be possible. However, if you have submitted rightly, only 3
The
witnesses
receipt of the
are there.
LCR, Lordship. First order, Lordship. Prayer. Lordship may kindly look into the first order.
First order
Lordship.
on date
On 21,
21/10.
5/9, 21/10. Ma'am.
And that's what I'm asking.
My
You did
lord.
not praise for any interim on that occasion.
Not even.
Not given, Lordship, that after receipt of the LCR, and LCR is received long ago, Lordship. And service is also complete, Lordship.
Yes, Sharma. In that case, he has a case because only 3 witnesses are there. He raising the law point that without any prior sanction, the case should not be proceeded or cannot be proceeded. That is his ground. Otherwise, he will be going to reply. Whether under what strength the prosecution is sanction is required or not, it will the nature of the case, whether prior sanction is required or not, or whether there is any sort of irregularity while taking cognizance. This can be considered. But he is saying that only 3 witnesses are being listed. Case is at the stage of evidence. If evidence is supposed completed, that purpose of filing it may become infructuous. In that
Madam,
case,
document fix on just reopening, madam.
okay, in that case, it is not.
And then it will take.
Not hampered. Okay. Part Mr. MP Hussain, the Danit Consultative Petitioner, Mr. Bishop, Danit Additional PP, everyone, statements, and MS P. Agarwal, the learned amicus, representing respondent party. And considering the submission made by the Danit Council for the Danit Additional PP, and then the matter be listed immediately after vacation. Just immediately on the 6th, it can be fixed. 6/1. I think it will not hamper you. 6/1.
They will also take time.
Conviction for 7 years. I filed an IA. And the last order, your lordship may kindly note. Order dated 10/12/25. Not a single eyewitness, 14 witnesses are there. He was convicted only on the basis of the 313 statements. This is what I find. Your lordship may kindly see page 18.
Your IA.
IA. No, in a main petition itself.
Oh,
Evidence copy is there. Page 18 is the evidence. He is not an eyewitness. All the eyewitnesses from 1 to 14, my lord, if I take your ladyship to all these eyewitnesses, PW1 is the father-in-law, complainant.
Otherwise, we have received the
Yes.
record, no?
So, my lord, nine
Since
months
when
in,
he is in custody of them?
9 months in custody. Total 9
months in
months in custody and 313 statements. I'll just point out one case, my lord, one page. Page 97 of the same main thing. I'll paragraph 105. Paragraph 105. Page 97. Page
105.
5. Let me just read this one. Now, from the appreciation of evidence of the prosecution witnesses, there is no prosecution witness as regard, my lord, seeing the incident, as well as the extrajudicial confession and admission of the accused made under section 313 of the CRPC, it is crystal clear that the accused person has no any criminal intention to kill his wife, but in a heat of a moment, while he strangled the neck of his wife, all this is on the basis of 313 statement. As disease tried to save her paramour from the clutch of the accused, her husband, while he discovered both of them in compromising position, she became unconscious and died. Now, page 43, your lordship will kindly say. 43, his 313 statements. Relevant is at page 47. May I read this one? Page 47. His 313 statements, paragraph 19. In the year 2014, I married so-and-so. I started my married life at so-and-so. While I continued my married life with so-and-so in my parental home, I came to know that she had illicit affair with her brother-in-law, so-and-so, Mumtaz Begum, sister of my wife. At that time, I was working as mason at Guwahati, and while my family member, as well as the other village people, informed me about the illicit relationship of my wife, along with Altaf. Altaf was the only eyewitness. They have not brought him. Altaf Hussain, and asked me to come to my home to settle the matter. I accordingly came to my parental home, but found that my wife already left to her parental home due to shame. Then I called a village meeting, and in that village meeting, my wife admitted before the village people that she had illicit relationship with Altaf Hussain, as she had love affair with him. Thereafter, she left my house as she was not willing to continue her married life with me. Thereafter, I shifted to Gwalpara and started my small business by giving a tea stall at so-and-so. After about 1.5 years, my wife again came to my home, and with the advice of the family members, I again accepted her, and both of us again started our conjugal life at Naya Para Gwalpara. And during that period, three numbers of children were born to us. On the date of occurrence, due to the rainy season, on that day, I closed my shop earlier and went home. I surprisingly found my wife along with Altaf Hussain in a compromising position. And while he tried to flee away on witnessing me, your ladyship goes through all the witnesses from PW1 to PW14. There is not a single eyewitness. Only eyewitness was the Altaf. So therefore, the statements under section 313, my lord, cannot be acted upon. Here, may I just point out only one decision? No, there is no other access. Yes, they have shown. Taken 164 statement. Yes. My lord, yes. Yes. That may be there on the record, but on the PW is, there is not a single PWs, my lord, who has given any, my lord, in regard to the incident.
That before those witnesses, you need any confession regarding the commission of theft.
No, it is not. Yes, it is not there, my lord. It is not there. The record will only show, my lord. No, 9 months has gone, Machine, my lord. It's a machine, he is a machine only. 9 months has gone, 7 years conviction. May allow him to go on with it.
My judgment is only on minus 18/7/2020. 7 years.
9 months has gone, not 2 years.
But 18/7.
No, 9 months has gone. Huh? 7 months. 9 months, my lord, from the date, from page 10. Calculation tools, man. Yes, 7 months or 9 months, my lord, I will calculate it. But on the page of the record, my lord.
My lord,
We would fix it.
my lord, my lord.
Yes. No.
I think. And if I'm already there, who already prepared evidence.
Yes. Yes. That's fine.
Fine.
But it,
Each order.
Already admitted.
appeal admitted. I'll- Diploma. Okay. No, we may be allowed to see the record for a while. Lulu. Uh, Extrajudicial. That I'll see. I understand. Of course.
Right, Mr. Lordship. Lordship, we have issued notice to the respondent number 2, however, to the address that they have filed, but however, it has not been received by the respondent number 2, so Lordship may allow us to take a fresh step.
You know the proper.
Lordship, Lordship, we have given according to the address that they have given, but it has not been received. Yes, Lordship. Yes, Lord. Yes, Lordship. Lordship, interim's order may continue. Lordship. Lordship, it's in the last order, 27/6. H. Kesimi on behalf of H. Chakrabarti, Lordship. H. Chakrabarti. Yes, Lord. Okay. Where is a Lordship? Lordship, this matter may be possible for the day. Possible for the day.
You are for the
Yes, sir.
you inform the you are for the response. You inform the other side.
On Lordship.
We decide after vacation. Yeah.
Kindly fix the date, Lordship.
Let's second.
On the last occasion, we have taken the first step on 21/11/2025, my lord. Yes, my lord. There is no office note, my lord. I've gone through, my lord. Only that step taken receipt is there on the last page. No, my lord. Can be TCR may be called for, my lord. For Suresh Chandra Bora, petitioner. This petitioner, my lord. Response number 2, my lord. Tikendra Sharma. One statement. Formal part. My lord, TCR has been called, my lord. TCR. There is an interim order. There is an interim order, man. Obviously.
May I please listen, my lord? My lord, earlier, my lord, can copy of the record has been called for from the special judge, I think, Kokrajhar, and it was not been received, my lord. And the case is, my lord,
It's already received.
no, scan copy is not received.
Okay.
But my lord, my humble submission is that, my lord, in this case, the petitioner before your lordship is a father of the minor child. The accused are on bail, and the charges are under POSCO, my lord, section 6 of the POSCO. And now, my lord, my lord, uh, I am challenging the bail petition, which is allowed. And my lord, the reason has been, I have categorically mentioned in this petition, and there is a third part, my lord, upon the victim, and the victim girl is surprisingly, my lord, is pregnant, and very mysteriously undergone surgery and delivered a child, my lord. And there is a third part by the, my lord, accused who are on bail upon
For quashing of a complaint case, my lord. There's an office note. ma'am. And service, the AD card has also been received. One of the problems in this case is the magistrate did not specify the offences in respect of which cognizance was taken. That was one of the grounds why interim was granted. But it is an allegation of, my lord, Marpit, my lord. The petitioners are accused of beating up the respondent number 2 and his family member. Interim order is there, my lord. My lord. I'm deeply obliging.
May I please, Lordship? Lordship, I on behalf of my senior I Rafiq. Service report has been awaited. I Rafiq. Yes, ma'am.
Do you have any other?
No, no, my lord.
You want
Compensate them. Yes.
maybe.
Two.
2 and 3 same, my lord. 2 and 3 same. One, we have made the victim as a party represented by her mother. Mother is the informer. Only I have my, because tomorrow is the date fixed in the lower court, my lord.
For?
Yes, my lord.
For
CC, for consideration charge. So, I,
not pass the order of experience. But obviously, it is before a child.
yes, ma'am.
Training of child or graduating. Then if you are successful in declaring you,
Right.
then may not be a case also. Right?
Yes.
They prepare for it.
Okay.
That can
So I think since this petition is pending for, we are for quashing. So liberty may given to file a petition there, madam.
Well, you are always at liberty.
Plus,
Pray for that.
we'll. Right.
You-
Yes.
Yes.
Record perhaps not received, my lord. That's all. So reminder may be needed. Yes, madam. Sorry, sorry,
20.
February.
Okay.
Okay.
Respondent number 2, claim. My lord, this is a quashing petition.
Informant.
The informant, Sabun Narjari, he was served, I think he has been served.
It's up.
Yes. Notice, we say. I think, Lord, he is from Udalguri.
611. It is 611.
Same.
Office notes, I said.
Office note 611.
611, I understand, my lord, notices were served. Means I said, no, sorry.
Or if they're not finding anything there, everything.
No problem. Bin रहा है नहीं ठीक है 16-12 डेट है अजी yes you know no it's awaited I think he also I have not he made a reminder for Will not here in this case, the trap failed. Actually, nothing is there in the end. Will not let the other side appear. The trap failed. Therefore, nothing is going to turn out from this case. Yes.
It was called. I mean, case of
Yes. No. Millard may have a date after the vacation, Millard. Yes, Millard. Could it be Millard in the
for out to 8.
8 is Millard, if it is possible. 5, 6, 7, 8, 9. 8 or 9? Oh, Bihu vacation. Or can we try on 7th, Millard? 7?
Okay.
There are two similar matters, my lord, arising out of the same complaint case. I am in 36, my lord. 35, sorry. 36 is the other one tagged in. They are appearing, my lord. So actually, average service report probably. Both are stayed, my lord. My lord, actually, we have given, my actually in the same case, I've checked, my lord, as told by my junior, that we have filed a wakalatnama in the other case. We are opposite party in that case. Probably because there were only 2 days in between, my lord. No, I'm the opposite party. We have filed a wakalatnama on. No. I don't know why they have made me because I'm the co-accused, my lord. They for some reason has made me, but since I have received notice, my lord, so I have submitted the wakalatnama.
We have submitted
Six. As an opposite party, and I'm the petitioner in 35. No. So because it's my lord, as I understand the law, the complainant is to be made a party, my lord. So I made the complainant a party, my lord. That's right. But they have made the co-accused also a party and have issued notice to us.
So in that case, you have already.
Yeah, I have.
It's okay, but the question is 35. You have not taken state even.
That is what I'll have to check through the Mori because there were only 2 days gap, my lord. Your lordship will see the order. With your order,
Yeah.
Just
10, 12, the order was there.
that's why, my lord.
Regarding your.
My lord, I think we should take fresh steps if not taken, my lord. I don't know.
Not taken. I have.
Because if they have come today, my lord, we have served the copy because the 36 was 1 month ahead, my lord. They have taken steps.
In item number 36, there is an interim option.
Ito piso to ba agay hinikulya?
They have already acted.
Yes.
But the main complainant is yet to appear, my lord. Kiman numbers one, huh? Respondent number Himanta Biswa Sharma kiman? 6 what?
That's one 5.
Kamar page mo ala na. Mulwa ke. 1, 2, 1, 2, 1, 2, 3 we have appeared, my lord.
You acted for 1,
2 and 3.
4 years.
4 I have not. 5 someone not yet. In our case, they are not the party because it's a complaint case. 35 minutes.
In item 35, you are not.
36 also. State is not basically a party because it's a complaint case arising out of a personal issue. Absolutely. Complainant is one, my lord. My lord. After vacation. Any date, my lord, after, say in the first week of February. Oh, over to maybe taking one.
D. Bora, carrying on behalf of S. Board.
Here, you take party.
No, not
No.
part.
Nepal. Well, in this case, 36, my lord, only one line should be added from our side that we have filed a wakalatnama on
1 to 3 December.
3rd December.
on 3rd December. Accordingly, it should be brought on record. Yes, sir. Not. Well, only. Even? 5. The 5 will be difficult, my lord. Let it be on the 4th, my lord. No, count. 4th will be 5. No, 4th will be. Go.
Lordship, can you fix on 20th of January date?
Apa? 18 will be better. How about I don't know. Orders of the Ibo? I'll take it.
18 is a holiday.
Oh,
February.
February. Yes. January.
5th of February is not convenient.
My lord, let it be on the 3rd, my lord.
3rd February. 3rd.
That will be better, my lord. Otherwise, it will be late. My lord, one line should be added, my lord. Interim stay order should continue, my lord.
Was there
Yes, both in.
Both. Yes.
Because one law point is involved, because this is the new law is coming up that before making somebody an accused, a notice is to be sent. So we have coined a term as proposed accused. Now, what is the procedure to be followed? Because lower courts are facing difficulties, so probably from this case, my lord, we can settle the law. And there are other laws coming from Kerala, Rajasthan, or Karnataka, and Allahabad. So we'll be placing all those. My lord, much obliged, my lord.
Obliged.
Eta ase no? Well, another item, my lord, just one moment, my lord. Oh, my lord, that is what I'm saying, my lord. Actually, in that case, are you going to
Yes. Here, going.
my lord, actually, I'm not prepared it. I was busy in some other case. I'm respectfully submitted. Also, I've checked with them. So let it come up after any date after vacation. Wait. After BU? No. Yes, no, actually, your lordship will recall, my lord, was aware of it, my lord. Probably my saying will refresh your lordship. But in the meantime, the accused died. So, my lord, the family members now want to remove the stigma. So, the family members has been substituted. We have filed an IA. Yes, your lordship only passed the order. Yeah, it's a lot. So, that way, my lord, we'll also have to do it because their pension and other benefits are also blocked. Sometimes people lost everything for nothing also, my lord. Today, your lordship has probably seen in the Times of India, just saying academically, my lord, after 13 years, a tutor who was the babysitter of the girl, my lord, he was convicted. So after 13 years, Supreme Court has acquitted him. The POCSO is very tough, my lord. That's why, my lord. Yes, my lord. Punishments will be a bit lesser, I think. Too harsh.
Category.
Category. Exactly. That's what I'm saying.
Third, 6, 7 years.
Yes, different manner. 12 different. Yes, we have two categories, below 12 and above 12. No? So there should be another half. Absolutely. Yes.
Fall in love with a boy
Yes, sir.
21 years.
Absolutely.
That
In earlier it was in the verge of majority. Now your lordship cannot do. Absolutely, absolutely. Very fine, ma'am. That approach should be there, madam. Much obliged.
Lordship, kindly adjourn for the day and the date may be fixed after vacation. Hearing matter, item 43.
hearing
Very complicated to list the matter, Lordship, because so many application we submit the registry, then after matter is not listed. So kindly a matter when
22nd of Jan.
.14 also adjourn for the day, Lordship. First week of January, Lordship, any date may be fixed. Motion matter, charge sheeted matter. Lordship.
Seventh of Jan.
Achha.
First.
May it please, Your Lordship. Your Lordship, this is a quashing application with regard to quashing of an FIR, Lordship, with regard to Bhangar PS case number 251 of 2021. Your Lordship, the background of this case is that the petitioner number 1 and the respondent number 2 were previously married. And petitioner number 2 is the
But
So what has happened in this case, Lordship, is that during the time of the marriage, Lordship, they got into several disputes. There were allegations and there were counter allegations, and as such, Lordships, there were various cases. So, Lordship, between the parties. So, Lordship, thereafter, Your Lordship, by way of a joint agreement, Your Lordship, they resolved their marriage. And one of the criteria for the agreement was that the list of those cases would be withdrawn. Your Lordship, if I may kindly take you to page number 21, Lordship. May I read, Lordship? Lordship, first paragraph. The marriage between the petitioner has broken down irretrievably due to irreconcilable differences, and there is no scope of reunion between them. Hence, both the petitioners mutually agreed that the marriage should be resolved on mutual consent by agreeing the following terms and conditions mentioned in the joint petition, wherein it is stated that number 1, list of 33 cases pending between the parties shall be withdrawn by each other immediately. Now, Your Lordship, this list has been annexed at page number, it starts from page number 32, Lordship. And this case in question is situated at serial number 32. Now, page number 35, Lordship, at serial number 32. The case in question.
Six.
36, Lordship. 30, yes,
Page number 35.
35, Lordship, serial number 32, Bhangar Police Station, 256 of 21.
32.
Lordship. Yes, Lordship, now, Lordship, on the previous occasion, Your Lordship, this Honorable Court inquired because subsequently an FR was furnished in this case. Thereafter, Your Lordship, the the informant had preferred a Narazgi application. Now, this court inquired with regard to the status of that Narazgi petition. To that effect, Lordship, we had filed an additional affidavit on 27/11/25. Perhaps it's marked as Annexure B in the record. Lordship. Lordship.
The pursuing and create the last order. Yeah. My lord, that is why my lord, as there is a executive matter, all the cases are withdrawn. But in this case, they have filed their objection, narrative petition there. That's why court, honorable court find that if their narrative petition is pending, my lord, how they will compromise, my lord? It means their objection,
Yes, Lordship. That's why, Lordship, may kindly come to page 67, the status report of the Narazgi petition, the order of the learned JMFC. Lordship, yes. Case record reveals that on 25/2022, the informant filed a written objection in the form of a Narazgi petition against the final report submitted by the IO of this case. And on the same day, the concerned learned Ilaka magistrate, after hearing the informant and after perusing the case record, was pleased to reject the final report and passed an order for further investigation, directing the OC of Bhangagar PS. It was also directed the office to send back the case diary to the OC of the Bhangagar PS. Since the Narazgi petition was already disposed of on 2022/5, perhaps that's a typographical error, Lordship, it should be 2022, and the said order dated so and so is still in force. Therefore, no question of disposing the Narazgi petition arises. Further, case record reveals that against the order of the further investigation dated 25/2022, again the final report has been furnished by the IO on 31/8/2023. So, Lordship, against the Narazgi petition, again the final report has been furnished. My case is that, Lordship, because this has arisen out of a matrimonial dispute, the apex court. The informant had filed a Narazgi petition.
Informant had filed a Narazgi petition in spite of the fact that there was an agreement for
No, Lord.
withdrawing of withdrawing of all the 33 numbers of pending cases. They were an agreement.
No, Lordship. The timeline matters because the agreement was entered into in the year 2023, the mutual dissolution of marriage. This Narazgi petition was filed in the year 2022, prior to the dissolution of their marriage.
But they have not withdrawn that narrative petition.
That is
Well, no, the question is definitely as per the order you have annexed as
Lordship.
an additional affidavit.
Lordship.
It seems that after filing of the Narazgi petition,
Lordship.
the matter was again forwarded to the OC for the further investigation. And after that investigation, they have again filed a final report.
Lordship.
So after the final report they have filed, now the case record filed finally report, and therefore FR assistant is hereby directed to take necessary recourse in respect of the final report.
Lordship.
So now another final report is still pending before the court. And do you have any information regarding this subsequent final report, whether again any Narazgi petition was filed? Now at present, I'm saying.
Present, Your Lordship, as per the, we have annexed the FR as well, Your Lordship, at page 69. The operative part is at page 68, with the type portion.
That's what I'm saying. The
Yes,
question
Lordship.
is that as you have submitted that this divorce petition was subsequent to the filing of the Narazgi petition, as per you.
Subsequent, Lordship.
Subsequent to the
Subsequent,
filing
Your
of the
Lordship.
Narazgi petition. But this order speaks that yes, it was subsequent and then it was again sent for further investigation or whatever. In that case also they again filed it, finally.
Lordship.
But the subsequent final report or the second final report
Lordship.
is still pending. You have any information in regards to the next or subsequent final report? Is there any steps taken by the assistant, office of the assistant, or is there anything? Because we are not in a position to say anything, because as per the last order, it was called for and you have submitted. The
Lordship.
order is also you have submitted as per order 1311/2020.
Lordship.
This is the latest order, last order.
Lordship.
So in that order case also, that means otherwise that the final report which was subsequent to the other filing report,
Lordship.
it has been placed before, but the assistant is not been placed before this one. So whether any notice was issued to the informant side or the this respondent to file, whether they have any objection, whether Narzi petition is another Narzi petition is pending, that is silent in this.
Lordship, yes. Lordship, the case is that, Your Lordship, the informant has not pursued this case since the year 2020. That is
I'm
the
right,
case.
but you do have any instruction in that regard?
That is the
Take
case.
instructions then. Huh?
Because, Lordship,
It is there? It is the quality. Yes, yes. No. As you are representing the informant side, or you are the amicus or what?
On behalf
Oh, whatever you are amicus. Although till now you don't have any information. That is the issue. Or if you have any information that she is not pursuing or she is not filing any, in that case,
Objection.
final report may be accepted by the court. So now we are not in a position to say anything. Because otherwise there may be some materials. I don't know whether the materials are available or not, but there may be a case for quashing. It may not be a case for quashing also. I'm just saying, it may be a case for
Doctor.
quashing and may not be also.
Yes.
So if it is not a case
Doctor,
for quashing,
my-
suppose, in that case, if final report is already accepted, your, this is, this is
will be quashed off, ma'am.
infructuous more or less.
Yes, ma'am.
So
Lordship,
now what?
my humble submission is that on page 68, Your Lordship, the FR says that inform the informant about the case by way of a notice. So, with regard to the FR, it has already been, the second FR I'm talking about, has already been
So
informed.
bring the latest order, last order then. Suppose what will be the order? Next order will be, suppose in that case, suppose notice is issued, it has been accepted by. Protector. If it is accepted and she did not appear, then court will definitely pass an order.
Yes, ma'am.
In spite of receiving notice, the complainant is not appearing or informant is not appearing, in that case, final report may be accepted. That may be one of the cases. So better to wait, I think. Otherwise, if I go by the hearing of this case, it
will take time.
may come out as a prima facie case is there, suppose. Then it may not be a case for quashing also. Let us wait for the order. Or if you can bring the last order of any acceptation of the final order, then it will be a case for even for infructuous. It will be automatically it will become infructuous, isn't it?
Lordship.
Can you get my point?
Lordship.
What I'm saying.
Lordship.
So now you have this last order you have submitting. It seems that after receiving the final report, second final report, a notice was again issued to the complainant. But what about the status of the
Whether it
case
is
and whether it
accepted or
has been accepted? That is the silent.
That will be accepted.
So the next date you do one thing. It may be easy case. I don't know. If next date suppose again final report is suppose accepted, then it's okay. If suppose final report is not accepted again, Naraji, then it may be case may be hard
Yes.
in that case. But at this stage, I do not think that.
Lordship, the thing is, my grievance is that what if there is a non-response from the side of the informant? Because if the notice is
Not the question, at this stage, not the question of non-responding.
Because-
But here it is the lordship query. What happened in the last occasion? What after issuing the notice,
be accepted.
whether it was they have appeared or not. That is the query, lordship.
And if they have not responded as you have submitted, they may not respond also. I'm not saying. If they have not respond, if she is not responding to your notice issued to her, in that case, the court may pass the final order,
accept-
may
fine.
final order, final report may
Accepting
be
the-
accepted. That will be the very easy case for you then. Okay,
Lordship.
you are Mr.
N.R. Sharma on behalf of AK Bhuyan.
Are Mr. Irkiman number
16.
Are Mr. N.R. Sharma appearing on behalf of
AK Bhuyan.
Mr. A.K. Bhuyan for the petition. Also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state respondent, and Mr. E. Bora, appearing on behalf of Mr. Ken Bhagadan, the learned amicus for the respondent. It is submitted by Mr. Sharma, the petitioner, that in pursuant to the order dated 1/11/2025, they have obtained a copy of order and the status of the Naraji petition. And to that response, they have also filed one additional affidavit bringing all the question, bringing the documents on bringing some orders and documents on record. He basically referred to the order dated 13/11/2025 passed by the learned JMFC Kamrup M in Bhangaghar in relation to Bhangaghar PS case number 250 in connection with Bhangaghar PS case number 256/2021, and accordingly submitted that after the second final report, the complainant is not responding and she is not interested to proceed with the hearing. But from the order dated 13/11/2025, it seems that after furnishing of the second of the subsequent final report, the office assistant was directed to take necessary steps in respect of the final report dated 31/08/2023. But after the said order, whether the informant of the complainant had responded to the notice or whether any order of accepting the final report has been passed by the learned trial court below is not available in the case report. In view of this, the petitioner is further directed to procure the subsequent order and also to apprise the court as to whether the learned trial court below had accepted the subsequent final report or the case is again proceeded on the basis of any narrative petition. Please the matter accordingly. You want any fixed date or after
Lordship,
vacation?
can fix a date, Your Lordship, after vacation.
Yes.
When?
After Magh Bihu,
21.
21 January, and by the time you just take out the certified copy of the order, if any order of accepting the final report is been passed by the court,
Sure.
or whether there is again any narazi, as you have submitted that they are not responding and they are not interested to proceed, then it's okay. Then a final report may be accepted by the court. Because Mr. Bora is, though he is for the respondent number 2, he is an MI direct contact. He has no direct contact. Not aware about the facts. Not aware about the facts. That is the issue. Okay. So we are fixing it on 21st of January 2026. Try to bring direct. It will be dispatched.
My lord, before starting my colleague, my lord. My lord, respondent number 2, my lord, although service completed, my lord, they have not appeared, my lord. They have not turned up, my lord. Respondent number.
Versus Neha, my lord, praying for initiating a proceeding as per 340 of the CRPC.
Oh.
So that was not done, my lord. That is why I'm here before the Lordship.
Otherwise, how your award was assessed by the court?
My lord,
Otherwise, it
yes,
was evaluated.
interim was that was directed. That is a separate issue. I'm not touching upon that part. I'm only
Product reproducing this false evidence.
yes,
and
my
all.
lord, yes. Because from her admission only, my lord, it is clear. I can show you, your ladyship, that she has admitted about the is a false evidence she has furnished, my lord.
But in that regard, have you filed any petition before
Yes,
the Learned?
we filed a petition. We even filed, we pleaded in the petition to file interrogatories as per order 11 of the CPC, because that is allowed. That is applicable as per the Rajneesh versus Neha judgment, my lord. That was also not allowed. That was also rejected.
Oh, against that order, you have.
Yes, yes, my lord.
You are Mr. R. Chakraborty.
Yes, ma'am.
Heard Mr. R. Chakraborty. Also heard Mr. B. Sharma. And BP. None appears on call for the respondent number 1. Name of 4 numbers of counts have been reflected in the cost list. By considering the submission made by the let the matter be listed after vacation for hearing.
Well, or
27 will do.
27 I'll be out of station, my lord. If it is on 30th, it is okay, my lord.
30.
30.
30 is
Or maybe on 2nd of February, my lord. Sorry, 3rd of February.
3rd of. Okay.
Obliged.